It's Thursday, September 27th. The Supreme Court on Wednesday upheld the constitutional validity of Aadhaar in a 4-1 majority judgment, but struck down and read down certain sections of the Aadhaar Act. What does that mean? Here are the big takeaways from the Supreme Court judgment. The big one, the Supreme Court struck down Section 57 of the Aadhaar Act. Section 57 allows not only the state but also any body, corporate or person or private entity to demand Aadhaar from citizens for the purpose of identification. It is based on this provision that mobile companies, private service providers were seeking Aadhaar for identification. So, private entities cannot demand Aadhaar to access services. No Aadhaar for obtaining or retaining of mobile connections. In fact, Justice Chandrachud in his dissenting opinion held that Aadhaar numbers shall be deleted forthwith by the telecom companies. He said mobile phones are a storehouse of information about lifestyle and preferences. Service providers shall forthwith delete any information collected by them after linking Aadhaar with SIM. Also, no mandatory Aadhaar for the opening of bank accounts. The court also clarified that benefits and services under Section 7 should be of the nature of welfare schemes targeted at a particular deprived community. Section 7 pertains to proof of Aadhaar number necessary for receipt of certain subsidies, benefits and services, etc. Which in effect means school admissions, for instance, does not qualify as a benefit under Section 7. So no Aadhaar for school admissions. No mandatory Aadhaar for CBSE, NEET, UGC. For enrollment under Sarva Shiksha Abhiyan and other education schemes that demand Aadhaar, the Supreme Court held that it cannot be made mandatory. Justice Chandrachud's minority dissenting opinion held the entire Section 7 as unconstitutional, but more on that later. So what will Aadhaar be mandatory for? PAN cards and IT returns. Section 139AA of the Income Tax Act has been upheld, mandating Aadhaar-PAN linkage. The section makes it mandatory for income tax assessees to quote their Aadhaar number in their tax return and link it to their PAN. To avail government benefits or welfare schemes, the funding for which comes from the Consolidated Fund of India, for instance LPG subsidy, or to access rations through the public distribution system, Aadhaar would be mandatory. But what about the documented fact of exclusion, that many people were denied benefits because of failure in biometric authentication? The Supreme Court majority judgment held that a lot of people who will benefit due to inclusion cannot be denied due to exclusion of a few. The court said we cannot throw the baby out with the bathwater. The court held that exclusion is concerning and that it is not trivializing exclusion but has taken on record the statement of the Attorney General that no one will be deprived and have also provided guidelines to prevent and minimize exclusion. Suitable provisions, the court held, have to be made in regulations for establishing identity when authentication fails. Justice Chandrachud in his dissenting opinion though held that Aadhaar has serious problems about exclusion and the right of marginalized to benefits cannot be made to depend on authentication of Aadhaar. Dignity and rights of individuals cannot be made to depend on algorithms or probabilities. Constitutional guarantees, he said, cannot be subject to the vicissitudes of technology. Ritika Khera, professor of economics who has extensively studied the implementation of welfare schemes and submitted research material in court in favor of the petitioners, said, "It is disappointing that the judges who have signed the majority opinion have believed the government's false assurances that nobody will be denied their entitlements due to Aadhaar. We know that the governments have been blatantly violating Supreme Court's orders since 2013, and in its present form, exclusion is built into the Aadhaar ecosystem. What about concerns on surveillance and privacy? The majority judgment, on the basis of the assertion by Aadhaar authorities that all information collected will be kept in silos, held that Aadhaar will not lead to a surveillance state. Justice Chandrachud, in his dissenting opinion, held that Aadhaar poses serious risk of surveillance and also compromise of data stored under Aadhaar. Many provisions of the Aadhaar Act provide for invasive collection of biometric data, and that the government's claims on security and safeguards have not only not been convincing enough, but falls short of standards required to protect privacy and data protection. Meanwhile, the Supreme Court also modified Section 47 of the Aadhaar Act, Section 47, which provides that no court shall take cognizance of an offence under the Act except on a complaint made by the Aadhaar authority, should now include a provision for an individual to file a complaint. The court also struck down Section 33(2), which permits the disclosure of information under Aadhaar Act, including identity and authentication information made in the interest of national security.
One of the key issues the Supreme Court was considering was whether the passage of the Aadhaar Act was legal. The Aadhaar Act was passed as a money bill, which is a piece of legislation that does not have to make its way through the Rajya Sabha. A money bill is a piece of legislation that deals with expenditure from the Consolidated Fund of India, which is basically all money spent by the central government. The government had argued that because the Aadhaar Act primarily deals with subsidies and benefits, it can be counted as a money bill. But the opposition, as well as the petitioners challenging Aadhaar, believe that because the Aadhaar Act goes much beyond subsidies and benefits, it should not be counted as one. In the majority opinion, Justice Sikri agrees with the government and says that the Aadhaar Act was rightfully a money bill. But in his dissent, Justice Chandrachud says that because it goes much beyond just subsidies and benefits, Aadhaar Act being passed as a money bill was unconstitutional and should not have been passed in the first place. How does this matter? Obviously, the majority opinion holds for the moment, but Justice Chandrachud's dissent lays a platform for further challenges in the future, whether to the Aadhaar Act or to other acts that go through this money bill process. It's also important to remember that Justice Chandrachud will be the Chief Justice of India between 2022 and 2024, which could mean many things in terms of how the court operates.
Clearing the air on reservation and promotion for employees from scheduled castes and scheduled tribes, the Supreme Court on Wednesday held that there was no need to collect quantifiable data on backwardness of SCs and STs before giving reservation. In an earlier ruling, referred to as the Aadhaar Judgement, in 2006, the Supreme Court had imposed 3 conditions: identification of backwardness, compelling reasons, and inadequate representation in public employment for granting quota in promotions to employees from scheduled caste and scheduled tribe communities. Wednesday's judgment, however, did not say anything on the collection of data on the adequacy of representation of employees from scheduled castes and scheduled tribes in promotional posts. Did US President Donald Trump just get laughed at the United Nations General Assembly? See for yourself.
In less than 2 years, my administration has accomplished more than almost any administration in the history of our country. America's so true. Didn't expect that reaction, but that's okay.